SJC-12979, Helen Brady v. State Ballot Law Commission and Secretary of the Commonwealth.
I'd also, by the way, would ask if any of you are not on a cell phone to silence your cell phone, and if you're not speaking to be silencing be using your mute button. So, Mr. Kenny, you may proceed.
Mr. Chief Justice, it's Clerk Keneally. Would it be prudent at this time to mention a recusal?
Yes, thank you. You may be wondering why we only have 6. I'm sorry. Thank you, Clerk Keneally. Justice Budd is recused from this case. So there will be 6 justices who will be deciding. Thank you, Clerk Keneally. I forgot all about that. And with that, Mr. Kenny, now you may proceed.
Thank you, Your Honor. Good afternoon. May it please the Court. My name is Christopher Kenny. I represent the petitioner appellant, Helen Brady. Justice requires that the Court vacate the State Ballot Law Commission decision and order the State Secretary to place Helen Brady on the ballot for the September primary election. Here's why. The Court will be reviewing this de novo because it involves errors of law and issues of constitutionality. No deference should be given to the Commission because it has no experience, technical competence, or specialized knowledge about electronic signature gathering. So there's no basis for the Court to defer to the Commission. Rather, the Court, in taking a fresh look at the record of this case, should vacate the Commission's decision because it's based on an error of law that Brady did not meet the Goldstein standard, and because affirming the Commission's decision would violate Brady's state and federal constitutional rights. A fair review of the record shows that Brady met the letter and spirit of the Goldstein decision. In Goldstein, at pages 531 to 532, there is a long block paragraph that contains the stepping stones of the Court's recipe for compliance with the new electronic signature gathering protocol. In looking at that, the Court should broadly interpret Goldstein to avoid a constitutional issue if possible, and that is possible here. It's clear that Ms. Brady's consultant created a software program that met the standard set in Goldstein. It allowed a scan or post of the nomination papers online. Voters could download the image of the nomination papers and apply an electronic signature with a computer mouse or stylus. The signed nomination papers would then return to the candidate or person working on the candidate's behalf, either in electronic form by transmitting the native electronic document or scanned paper document. Goldstein does not define the terms electronic document or native. Black's Law Dictionary does, however, identify electronic document as any electronic media content other than a computer program or system file that's intended to be used in electronic or printed form. The signatures and other data provided by the voter here clearly fall within this definition, and they were provided to Venue X Media in their native electronic format. The Goldstein case does not require more than that. However, the Commission latched on to the Secretary of State's advisory and erroneously gave it the force of law when it doesn't deserve that treatment in this circumstance because there was no notice and comment period. It is not a regulation. So in the Court's prior ruling of Mass General Hospital versus Mass Rate Setting Commission, no weight should be given to the advisory in adjudicating this process. If the Court were to rule that the Commission's decision or the advisory impose voting requirements that alter or exceed Goldstein, the requirements should be struck down because they significantly interfere with the fundamental right to vote. In short, the Commission decision itself was entered long after the period for Ms. Brady to have collected signatures, so it would have been impossible for her to comply with these if they're deemed to be new voting requirements. The Court must apply a strict scrutiny standard to these voting requirements if they're deemed to be such, and the state must show that they are narrowly tailored and advance a compelling state interest. The Court made that clear in the Chelsea Collaborative case. The Commission decision and advisory are not narrowly tailored. They are expansive, and they add burdens and definitions and procedures that the Court did not put into the Goldstein decision that binds Ms. Brady's procedure. And these other processes that the Commission and Secretary sought to inject into the Goldstein standard are not necessary to advance a compelling state interest. As Justice Kafker persuasively outlined in his concurring opinion in Goldstein, technology now allows for reliable use of electronic signature images. As he pointed out, the Registry of Motor Vehicle now allows images of signatures to be used to create the new Commonwealth Voter Registration Database. Ironically, even this court allows the lawyers who appear before you today to have filed our briefs yesterday with a simple \S for our own signatures. Moreover, the Supreme Judicial Court and single justice sessions in the past 2 months since Goldstein have progressively clarified electronic signature processes with new details and definitions that are not found in Goldstein. This shows a lack of clarity in Goldstein. Everyone commends the court for the quick action you took in reviewing and deciding Goldstein. Because it was such a quick action, the circumstances were not perfect, and the process, therefore, was not perfect either. It has been perfected in subsequent decisions like Dennis and Better Future Project and Christian. None of those, however, are binding on Ms. Brady. She is only governed by the Goldstein standard, which has none of the safeguards the court has built into this standard and procedure as it's evolved over the past 2.5 months. Now, before the court, in addition to the appeal from the commission's ruling...
Mr. Kenny, you've already been more than 5.5 minutes, so I'm going to stop you now, and I'm going to invite questions for Justice Lang.
Thank you.
Do you have any questions?
Hello, am I off mute now?
Yes, you are.
Hello?
Yes, we hear you.
Am I off mute now?
Yes, we can hear you.
Hello?
We can hear you.
Hello?
We can hear you. You can
Hello?
speak.
Animation.
I'm sorry, I can hear you, Justice Lang. Is there anybody else who cannot? Why don't you just ask your questions?
Hello?
Yeah. Are you not able to hear us?
Hello? Hello? Can you hear me?
We can hear you.
Oh, okay. Fine, good. All right, I'm sorry about that. Mr. Kenny, good afternoon.
Good afternoon, Your Honor.
I have a few questions about the argument regarding equal protection that I know you haven't reached yet this morning, but this afternoon. But could you tell me, really, please, now that you've had a chance to look at the pleadings filed by your opposition and the intervener, what it is that you say to the essential argument that you have no equal protection argument because, after all, you are in the position of somebody who's been speeding just as everybody else on the road has been speeding, but you're the one who gets picked up. You're the only one your client's the only one that had a complaint brought against them, so that you really don't have an equal protection claim. So I understand it. You see, it's the argument.
Pardon me?
I said that's my understanding of the argument. Would you like to enlighten us?
Yes, please. Thank you, Your Honor. The equal protection argument is based on the fact that the evidence shows that several candidates, up to 39 other candidates, use the same software protocol, and that we have in the record evidence that at least 4 of them, Colarusso and Kevin O'Connor and Hall and Campbell, used this specifically. 3 of those 4 have been qualified for the ballot using the same procedure that Helen Brady did. And when the State Ballot Law Commission decided to say that she cannot be on the ballot for that process, she's being treated differently than those other 4 candidates who have used the same protocol and do have access to the ballot.
Yes, right. But I mean, if none of you complied with the appropriate precedent, aren't you in the position of being like the speeder who's just complaining that the other speeders didn't get stopped?
Well, I think, Your Honor, my argument is more like that the state police had everyone stopped and only issued a ticket to my client.
Okay. I got it.
The commission had authority to investigate this and to take action and did not.
Okay. I don't have anything else, thanks.
Justice Gaziano.
Yes, thank you. You open up by saying that you satisfy the letter and the spirit of Goldstein, and you may have satisfied the spirit, but as far as the letter goes, wouldn't you say that our precedent requires the signed nomination paper to go back, and this was basically the data from the signed nomination paper, not the signed nomination paper itself, to be forwarded. What do you say to that technical argument?
Your Honor, the native document that we say controls here is the voter input onto the image of the nomination form. That information was all input by the voter and is saved in its native format and applied electronically to the form that's printed out.
Yeah, I don't know if that's stretching it a bit because nowhere does it say it's the data or it's the free-floating signature that controls. It's always been the nomination paper back when it was envisioned before we got into this and in Goldstein. So I don't know how the data substitutes for the paper.
Your Honor, I'd simply say that the Goldstein decision talks about electronic application of the signature. That has to be done. And
perhaps we obviously didn't envision this in Goldstein, and that's where your spirit argument comes in.
Yes, Your Honor.
Okay,
yes.
Thank you. I have no further questions, Chief. Justice Levy.
Yes, good afternoon, Mr. Kenny. I'm not as concerned about whether or not in the end, the signatures are on new nomination papers and not the actual nomination papers or not. I'm more concerned with the argument that we have heard from the appellees about the potential use of these voter signatures to be applied to other documents and the implications of that. Could you address that, please?
Yes, Justice Lowy, thank you. That concern about whether they could be misused is entirely hypothetical and, in fact, is not an active concern here because the State Ballot Law Commission specifically found in paragraph 24 of their findings of fact, which is at Record Appendix page 109, that there was no testimony or evidence presented indicating that the signature images or any other voter information obtained on behalf of the respondent were used or applied to any other document or nomination paper other than those of the respondent. There was testimony from Mr. Fitzgibbons, which we credit, that no such thing was done with this information collected by the candidate who used venue X. So it's a strictly hypothetical concern. There are concerns with the old paper ballot. We know from one of the cases that the Secretary cited in a footnote in her brief that someone had put a different ballot access paper on a clipboard and sort of tricked people into signing that with wet signatures. So there's always a hypothetical possibility. Here, however, it's been put entirely to rest by the Ballot Commission itself.
Okay. Just one more question. This doesn't go to the constitutional issue. It goes to what type of review we're looking here. This is 38 review as it relates to the State Ballot Law Commission. And you referenced in your argument that this is really de novo review of the Secretary of State's advisory. But it was we really in Goldstein talked about having the Secretary of State provide guidance to prospective candidates about this whole issue of the electronic signature collection. What does that say about the level of review that we should be giving to the advisory?
Your Honor, the Secretary of State's advisory is not accorded the force of law. That's from the Mass General Hospital case I cited earlier. It simply didn't go through the notice and comment process that's necessary for it to have the force of law. It's a guide, it's a reference, but it does not have the force of law and cannot be given any weight in the adjudicatory process here.
Even though it was really as a result of an order of this court to the Secretary?
Yes, Your Honor. The language from the court in Goldstein asks orders the Secretary to provide clear guidance that may assist the voters in effectively achieving this, but it doesn't say shall be used, must be used. It's guide, and under the Mass General Hospital case, it is not the force of law. The Goldstein decision is the force of law. Thank you.
Thank you.
Justice Miller, any further questions?
No, thank you, Chief.
Okay, Justice Seifer.
Thank you. I may have missed this in the filings, but do the backups, or actually not the backups, but the original electronic version of these signatures, does that still exist, or did that get converted and changed?
Yes, they still exist.
Okay. Thank you. I have nothing further.
Justice Seifert, they were marked as an exhibit at the State Ballot Law Commission hearing.
Okay. Is that, do you know which number that is? Is that, I was looking at some, so I'll find it.
I believe, Your Honor, it was Exhibit 7 and 7A at the State Ballot Law Commission trial, and I can get you a record appendix for that.
That's fine. I can do that. Thanks.
Thank you.
I have no further questions.
So, Mr. Kenny, I have a couple of questions. Is anyone actually using the exact Goldstein standard out there? Or is everyone sort of improvising some?
Your Honor, at the State Ballot Law Commission hearing, there was no evidence presented of any other methodology other than Brian Fitzgibbons of Venue X that met the Goldstein standard. There was absolutely a dearth of evidence presented.
Well, was anyone literally taking the electronic document signed and emailing that document? Or was everyone, all the different methodologies out there, different from that? Whether they're in compliance with Goldstein or not, was anyone actually taking the electronic document with the signature and then making a PDF of that and sending that in, or was everyone doing some variation, some slight variation on all of that? Meaning not just your clients, but all the people using electronic signatures out there.
Yes, the best I can say, Justice Kapker, is that Mr. Fitzgibbons worked with 40 other candidates, and that we know that 4 candidates who have made the ballot worked with his system. Those were Hall, Colarusso, and Kevin O'Connor. Campbell used the system but did not get the number of signatures necessary, and Brady used it and got the requisite number, and they were certified, but here we are. So we're hoping that she'll be the 4th one that makes the ballot.
And just in terms of form versus substance, is there any substantive difference? I understand that, capitalization may be, some of the text is capitalized, but is there anything substantive different from what was sent in, as opposed to what was signed? Or is it just, there's some difference in capitals, there's some difference in placement? Anything substantive different?
No, Your Honor. The voters input all of the data into a database that was stored and then electronically applied to an image of the nomination form. So it was the voters' creation that was printed on the form.
I understand the voters' information was the same. I'm trying to understand because I understand why we don't want to have a nomination paper that is changed, that the voter looked at one nomination paper and then the ballot commission is seeing a different one. That seems to me troublesome, but it seems like, and there is a difference in the document here, but there's no substantive difference. Is that correct?
That's correct, Your Honor, and it goes to the point you made about form over substance, because the commission itself made a specific finding in paragraph 25 of its findings of fact that it credits Mr. Fitzgibbons' testimony and received no evidence to the contrary that the persons listed on the petitions sent to the campaign and subsequently certified by local registrars had, in fact, signed or at least made some mark with computer mouse or stylus in the signature box before clicking submit on the screen to place respondent's name on the ballot. In other words, the State Ballot Law Commission has found that these 1,066 voters actually signed in the signature box to indicate their intent and desire for Ms. Helen Brady to be placed on the ballot. And that's the substance, Your Honor. That's the substance which should be placed.
Mine's a slightly different point. I understand that the ballot commission wants to make sure that the voter signed the same document, meaning reviewed the same document that is being submitted to the ballot commission, so that you didn't change some substantive part of that paper. But it doesn't sound like that occurred here. It seems undisputed that the substance of what the voter looked at and the substance of what was sent in is exactly the same. Forget about what the voter added to it. I'm talking about the nomination paper itself. Is that
Yes,
right?
Your Honor. That's correct.
And one last question. If we're uncomfortable about this information, as Justice Lowy just pointed out, being collected and potentially used, could we order it destroyed, or is there something in the election laws that requires those documents to be saved over time?
I don't believe there is, Your Honor. I believe that the court could require that it be destroyed. And I would note that in the subsequent rulings from the court, Dennis and Better Future Project and Christian, the single justices have evolved the standard, have brought it along, and now have a specific requirement with regard to preserving information and limiting the inquiry of personal information. So the system has worked. The problem is that Goldstein was the first crack at this under an emergency condition, and the court did the best it could. It's in a much better place now with the orders it's issuing, and virtually all of the concerns have been addressed in the newer orders that I've listed. It would be unfair to apply those retroactively to Helen Brady, who's governed by the Goldstein standard.
Thank you. That's all I have.
Mr. Chief Justice,
Thank you, Your Honor.
I've got a few questions, Mr. Kinney. It is my understanding from the record, and please correct me if I'm wrong, that when a voter filled out the form with regard to Mr. Brady, that after signing it electronically, the voter got back an email essentially saying you have just, signed a nomination paper for Mr. Brady, and here is a PDF of what you have signed. Is that correct?
That's correct, Your Honor. We refer to it as the receipt.
The receipt. But the receipt is actually essentially a PDF of what the person actually filled out.
Yes, Your Honor.
So that one was not one that you sort of redid. That was essentially precisely what the voter had signed.
Yes.
So I guess the question is, and I'm not sure the record reflects it, why not just gather those up and just submit the PDFs, as opposed to taking the names, taking the signatures, doing this so-called mail merge, and then creating another document and then inserting it into another document?
I'm not sure, Your Honor. I believe from Mr. Fitzgibbon's testimony that it was an issue of efficiency. Doing this, where they would print out by town was more efficient. There was also a date stamp on the receipt, and that also was another indicia of reliability that the voter got back, confirming that it was their input and when it was dated and signed.
But that's on the PDF, the date stamp.
Yes, that's right, Your Honor.
And then apparently you sort of typed in the date. Is the date typed in onto the form that was actually submitted? Is that right? Am I correct with that?
Not on the one that's actually submitted, only on the receipt that goes back to the voter, Your Honor.
Okay, but there's a typed name that's inserted.
Yes.
So
yes, the voter types it into a signature box, and that is it's prominently marked "sign here" for the signature line. They type that in. That is applied to the receipt and comes out with the date stamp that the voter gets. So there's no, the voter was not going to be hoodwinked. They have a receipt of what they actually did. And then that same data is then electronically applied to an image of the nomination form that is printed out and filed with the registrars and the secretary.
So what do you say we should do if we say, it really would be a lot cleaner if they had just sent in the PDF, and we're not thrilled about allowing what happened here to be done because it has a potential for fraud, albeit no indication that there was any fraud here. How do you win if we basically say, we understand that all the people who purported to sign actually did, so we're not worried about fraud here, but we're not really prepared to bless what actually happened in this case? What do we do?
We were in a closed window, Your Honor. The Goldstein decision is limited by its express terms to this primary election. Ms. Brady, as my understanding is, she's the only one affected in this circumstance. No one else. No other candidate, to my knowledge, has been challenged based upon this electronic signaturing process that's at issue in this case today. In other words, I don't think this is going to repeat itself. I don't think the court would be blessing a process as precedent that would come back to haunt anyone. I think rather it would be viewed as inequity, a way to place substance over form and to effectuate the voters' intent when 1,066 of them undisputedly voted their signatures to put her on the ballot. So I don't think it's a problem like that, Your Honor. It's not likely to repeat it.
I'm sorry. Well, I mean, we hope not. We hope that we'll get a vaccine before the next election.
That's true.
Are there any further questions of any of the justices?
Can I ask a follow-up question on your PDF? Does the PDF contain the full nomination paper as well?
Yes.
Or is the PDF... So the PDF would include the document that the person saw and the signature, so everything would be in that PDF?
Everything, Your Honor.
Mm-hmm.
Everything.
Okay. All right. Thank you.
Any further questions? Hearing none. Mr. Kinney, thank you. And we'll turn to Ms.
Thank you, Your Honor.
Chief, at one point is your voice is hard to hear, unlike everyone else's.
Oh, I'm sorry. For some reason it's easier for me on speakerphone, so maybe I'll move to speaker. So please tell me if that's the problem.
It's a little better.
Okay, that's because I'm on speaker, so generally it's better without speaker, but okay, I will stop mumbling. Ms. Kaplan, you may proceed.
Thank you, Chief Justice. Good afternoon, Your Honors. In Goldstein, the court addressed a specific problem, which was that candidates could not connect with voters in public places to obtain signatures on nomination papers. Therefore, the court made limited accommodations for the candidates, including allowing a narrow form of electronic signature
now joining
that mirrored as closely as possible the usual process for collecting signatures. The Goldstein process essentially allowed candidates to convey nomination papers electronically to voters, who were, for the most part, remaining in their homes, and then for the voters to convey the nomination papers back to the campaign. Goldstein did this by allowing a voter to first download an image of a nomination paper, and then either print out a hard copy, which there is no evidence that anyone did here, or apply an electronic signature with a computer mouse or stylus to the nomination paper. The voter could then return the nomination paper electronically to the campaign by transmitting either the native electronic document or a scanned paper version. Applying this language to brand new software, the Commission reasonably concluded that the software does not comply with the limited electronic process this court envisioned for several reasons. First, in the software, the voter is not applying an electronic signature to the nomination paper that is to be filed with the clerks. Rather, the voter enters a signature into a box, which is to be later applied to the actual nomination paper that gets filed. The voter also is not returning a native electronic document to the campaign, but is instead simply sending their data and an image of their signature to a third party, which then later generates documents through this mail merge process. Now, Brady tries to contort this language from Goldstein by suggesting that voters' data went to venue X in its native form, but the common meaning of a native electronic document isn't just raw data that has been removed from the document on which it was placed and stored in a separate spreadsheet, but rather the signed document itself. This conclusion is also consistent with the Secretary's advisory, which issued at the court's direction to implement Goldstein. The Secretary advised that a voter must apply their signature to the nomination paper in person and in real time, suggesting that the signature is applied to the final nomination paper at the time that the voter signs and not at some later date. Finally, all of this is not merely technical hair-splitting. Goldstein authorized a narrow form of electronic process that had never been allowed before, and this software simply failed to adhere to that process. Moreover, the Commission is specifically tasked in its authorizing statutes with responding to claims of fraud, and indeed has seen bait-and-switch type fraud in the past. Though there wasn't any evidence of that here, the Commission was rightfully concerned about allowing the use of software that has the capacity to easily apply voters' signatures to something that they did not intend to sign. And with that, I'll take the court's questions.
Okay, thank you. Justice Lang.
Hi, am I off of mute now, or am I still on mute?
No, you're good.
Yeah, good. All right, good. Well, let's start with the last part. If you're so concerned about fraud, why aren't you concerned about the other 37 people who are using the same software?
Unfortunately, as I think we discussed in our brief, neither the Secretary nor the Commission has the authority to act as a roving investigatory authority investigating into the process by which candidates gather their signatures. The Chapter 53 actually requires the Secretary to limit his review when he receives nomination papers to the face of the paper itself. And so if on the face of the paper it appears that all the information that's required is there, the Secretary doesn't have any further authority to reject those papers by virtue of the process by which the candidate used or by which the candidate gathered them.
So you're saying that if the Secretary in fact had factual knowledge that there was a terrible fraud going on in one person's campaign and nobody complained about it, that the Secretary had no authority whatsoever to investigate, nothing to do about it? Actual knowledge of fraud.
I don't believe the Secretary would necessarily have anything that he could do about that. However, in an event where the Secretary has actual knowledge of fraud, it is
now exiting
that
Jim Roosevelt
would also be available to candidates who are not necessarily to candidates, but to registered voters in the district of the candidate who committed the fraud, and would have the ability to raise an objection before the Commission.
So those people could raise an objection, but could the Secretary communicate to people that there was a fraud going on that he had actual knowledge of, so as to evoke a complaint? I'm just wondering if he has to sit silently by and watch the fraud being committed in the way people gather papers, gather signatures, knowing that having actual knowledge of fraud, does the Secretary have to stand by and do nothing?
My understanding is that the Secretary is not empowered to independently investigate fraud, but I would have to confer with my client with respect to whether there are any limitations on the Secretary sharing that information with a registered voter who would be capable of filing an objection in that circumstance.
Okay, thanks. I don't have anything else.
A letter to the court after the argument with respect to that question if the court would be interested.
I would be interested. I don't know if the Chief is interested. Is the Chief interested?
I'm happy to hear the answer to that.
Okay, good. Fine, then I'm all done with you, thanks.
Justice Graziano.
Just one quick question. The board found that there was a violation, or the Commission found that there was a public policy violation based on the kind of, I guess, reckless use of the signatures. But wouldn't you say part of the public policy is that which we recognized in our decision regarding ballot access during the pandemic? So that finding of a breach of public policy doesn't take that into account?
I think the Commission, like any administrative agency, is required to consider the reasonable implications of the matter before them. And so, that is an issue that the Commission considered. It's clearly an issue that others have recognized as relevant to this question by virtue of the fact that that issue is raised in the Dennis and other subsequent orders implementing Goldstein. So I don't think there's anything that bars the Commission from considering that issue. But I do want to emphasize that the Commission's main reasoning here is not the public policy considerations related to voter information privacy, but rather the fact that the process used here does not comply with the process set forth in Goldstein.
Right, but to the extent that they considered public policy, they probably should have considered ballot access public policy, correct?
Certainly the question of accessing the ballot is always before the Commission, but the Commission's role is to ensure that the election laws are faithfully adhered to, and sometimes that may result in what may appear at some level to be a highly technical application of the law to the facts. But the nature of election laws is that they are highly technical, and that there's a reason why strict application of those laws is required, and that's because that's what we need in order to ensure an orderly administration of elections that gives equal chance to all candidates to participate and sets forth the same rules for every candidate to participate.
Thank you.
Justice Lowy.
Thank you. Captain, I think I want to follow up on Justice Gaziano's point a little. Let's assume that the process here did not comply with the letter of Goldstein as it relates to the signatures that were submitted. Didn't we recognize in Goldstein that there were a lot of unanswered questions here, and we're dealing with trying to address ballot access in the midst of a pandemic? And even if the Ballot Law Commission is correct as to its interpretation of Goldstein, that we have a bit of a moving target in the midst of a pandemic, and that it really would work an injustice here, as Justice Gaziano was asking about, if we didn't have access here to this candidate. What would your response be to that?
Your Honor, I think this court absolutely did recognize that we were faced with a lot of unanswered questions at the time the court decided Goldstein. And the reason, that was one of the driving reasons why the court specifically allowed only a very narrow form of electronic signature gathering. The court recognized that ordinarily this kind of what is effectively a determination of public policy to even allow electronic signature gathering is something that would be reserved for the legislature. And so I think when the court decided to do that, it specifically struck a line that was as close as possible to maintaining our current election laws, which the court in Goldstein and in prior cases had already held to be constitutional. So I think that what the court did in Goldstein was strike a very narrow path that allowed certain forms of electronic signature gathering that essentially came down to the voter receiving an electronic nomination paper, signing that paper, and returning that paper back to the campaign, and nothing more. And I think that...
Well, I think that's a good point. I think that's a fair point that we were concerned about having too broad a definition of electronic signatures. But one of the reasons for that was that there were so many issues out there and so many unanswered questions about how all this would work that that's where we were. And things seem to be moving at an awful rapid pace in the midst of a pandemic. And are we stuck in stone with that right now?
I think the answer is yes, Your Honor. Goldstein was issued at a time when all candidates were still collecting signatures, and Goldstein effectively altered the
now exiting
Barbara Lang
for that process. And I think to after the fact say, well, the facts were
now joining
and
Jim Roosevelt.
Perhaps we should have either been more clear in what we said or adopted a different form of electronic signature gathering or been more flexible. That would be to change the rules after the fact. And in general, we don't do that in the elections context. We make the rules clear before the deadline for candidates to file their nomination papers.
Thank you, Stephen. That's all I have, Chief.
Just a safer.
Thank you. Counsel, often when dealing with electronic issues in law, we look for an analog comparison. Do you have any cases that are an analog comparison that would deal with the basic old paper cases that would be similar to this?
I have a few, Your Honor. I'm not sure if this is exactly what you're looking for since they don't, for obvious reasons, deal with the electronic context. But,
right, but I'm just looking for a good comparison.
Certainly.
now joining
Barbara Lang.
There's the Garrison versus Merced case, which is 33 Mass Appeals Court 116. That case had to do with the failure of a party candidate to include their party name on their nomination form. And and that candidate was ultimately barred from the ballot because the rules for nomination papers require the party name to be on the nomination form. And the reason I think that case is particularly analogous here is that the reason to put a party name on the nomination form is so that the people signing know what party this person is seeking the nomination of. And in that case, the court actually said there's no evidence that any voter was misled that this person was seeking the Democratic nomination, but yet we demand strict adherence to what's required on the nomination form because we need to be concerned about the possibility that a voter could be misled. I would also direct the court to this court's decisions in Walsh, which is 430 Mass 103, and Hurst, which is 427 Mass 825. And these deal in a similar context with requiring exact copies of ballot petitions to be circulated to voters to sign. And in particular, in the Hurst case, it talked about extraneous marks that might be on the ballot petition, even marks that weren't even necessarily intended to mislead voters. And the court said, we can't allow extraneous marks because of the potential to mislead voters, and we're not going to get into an ad hoc analysis of whether these particular excess marks would have misled voters or not. So in general, the courts have required strict adherence to what the election laws demand. And I think this kind of departure is not simply elevating form over substance, but would be allowing an entire process that goes beyond the process that this court envisioned when it allowed electronic signature gathering under Goldstein.
Okay, I have one more question, and I thought I understood this until I was listening to the arguments, and that is the other candidates who filed electronically, did they use the same software program, or were they using different programs? Somebody referred to her software consultant.
To be clear, there's no evidence before the commission with respect to what software, if any other particular candidates used. There was
so you don't know?
We don't know. That's right. We know that ultimately, I think it was approximately 380 candidates statewide got onto the ballot for the upcoming September primaries. So there were certainly many candidates who got onto the ballot without using this particular software. But whether those other candidates used other forms of software, whether they tried other forms of software, and then went.
So do you know that this candidate is the only person who used this software?
No, we know that there are at least two candidates who will be on the ballot who used this software.
But no one complained.
But no one complained as to those candidates.
Okay, I'm content. Thank you.
Justice Kessler.
Well, we know that 38 others used it too, right?
Yes.
We know that 38. He testified. He's the only witness. He said 38 people used it, right?
Yes, although we don't know whether they used it exclusively or even whether they filed any papers that they collected in that form.
And again, back to form versus substance, because this is important, right? This is whether the voters of this district have a choice, right? Is there anything substantive different from what was filed from what was signed by the voter? Anything at all? Give me one bit of substance.
When you ask about substance, Your Honor, are you referring to the content or specific?
Yeah, the content. The content. This isn't a case where the voter was shown horse slaughtering, as in one of the cases, and actually was voting on, I can't remember, a gay marriage initiative, but it was something totally different. Was there anything substantive different from what the voters saw versus what was submitted?
No, what the voters saw was a version of Helen Brady's nomination papers, and ultimately what was later submitted was a different version, but of Helen Brady's nomination papers.
And it's the difference is there's a couple of capitalizations, and there's some spacing issues whether it was above the signature line as opposed to in a box, right? Literally, we're talking about computer programming differences, right?
Yes.
And that is we're comfortable knocking someone off a ballot on this kind of technical, basically a trap for the technologically unwary. That's how we're going to decide who gets to vote for Congress for that purpose?
I would disagree with that final characterization, Your Honor.
Tell me why it's wrong.
I think it's wrong because I think the language of Goldstein is clear as to what was permitted, and I think that this program does not comply with the language of Goldstein. So it's not merely elevating form over substance. It's saying this court issued a ruling, and this candidate, and admittedly some others, went outside of what this court allowed in its ruling. And to allow her to get on the ballot would be to allow her to get on the ballot without effectively complying with the election laws as they stood at the time.
Didn't our decision, again, I was a concurrence, not because I was concerned about this kind of technical, kind of technical non-compliance as opposed to actual non-compliance. But is there, again, anything meaningful here? Because we know from the PDFs that it's the exact same document. We know there was no fraud. Nonetheless, and we also, the SJC was asking the Secretary of State's office to provide guidance on how to do this. It doesn't look like there was much in the way of guidance, was there? What was the guidance they provided on how to do this so that we wouldn't have this type of technical issue?
The guidance that was provided, I think the key language was that the voter may use a computer mouse or stylus applied to the signature line of the nomination paper screen image to sign their actual original signature in person and in real time.
By the way, haven't you all agreed in the subsequent decisions, both the Secretary of State and the AG's office, as well as the opposing parties, that it doesn't need to be on the signature line? It can be moved, as long as it's on the document, it doesn't need to be on the exact signature line, because again, it's a technical computer issue that raises, right? We've moved beyond that point, haven't we?
I'm not sure about that. I'm not sure I'm understanding Your Honor correctly, but I will say that the Dennis order, which was the order that pertained to ballot petitions that came out very shortly after Goldstein, had a provision that said the signature is affixed to the electronic version of the form in a manner where its position on the document cannot be changed. So the issue is not so much...
Isn't that exactly what was done here?
No, Your Honor.
Isn't the Dennis change compliant with, isn't that compliant with what was asked for in Dennis?
I'm sorry, I don't understand your question, Your Honor.
In Dennis, there was the parties, meaning the AG's office, the Secretary of State, and the ballot people, all agreed to a modification of that signature line requirement, right? They all thought it was kind of overly technical and agreed to allow that change, right?
They agreed to obviously the language of the judgment in Dennis, which I have to say I'm unfortunately not familiar with the above the line or below the line issue that you're raising. However, it's very clear that they agreed to language that would require the signature to be affixed to a specific spot on the form and not moved thereafter. And in the defendant's opinion, this software would not necessarily comply with that because it does not affix a signature to a place on a nomination form, where that nomination form is then sent off to the clerk's offices to be reviewed. Instead, it takes the signature in a box, essentially captures an image of that signature in a spreadsheet or in a combined file of signatures, and later applies those images of the signatures to other nomination papers. So the signature is not affixed to what the voter originally signed.
My last question is, if we're concerned about the security of these stored documents, can we order them destroyed, or is there some election law or public document retention requirement that we would be violating if we did that?
My understanding, Your Honor, is that the only public documents that couldn't be destroyed are those nomination papers that were eventually filed with the Secretary's office. So there's been some discussion in the single justice proceeding and with my brother this afternoon about Exhibit 7 and 7A, which are impounded. Those are the input files, which is the actual data that the voters submitted on Helen Brady's website. That contains data that exceeds the information that normally must be put on nomination papers when a voter is signing. That data is maintained by the private company here, not by the Secretary's office. So I don't believe.
So we could order that destroyed. We could order that destroyed then.
I believe it's in the hands of a private company. I'm not certain that. Well, I suppose this court could potentially order it destroyed, even if it's in the hands of the private company. I would have to confer with my client about that as well.
Okay, thank you. That's all I have.
Mr. Chief Justice Gantz, if they had submitted, if Ms. Brady had submitted the PDFs for the 1,000+ signatures as opposed to what they did, would you be here?
I'm sorry, the PDFs with the 1,000. Do you mean the original PDF receipts that were returned to the voters?
Right. If they had simply, when they emailed it to the voter, had copied themselves and printed those out and submitted those, would that be in compliance with the law?
I believe it would, Your Honor. If the Goldstein decision clearly says that if you apply your signature to a nomination paper and print it out and send it back, that is an acceptable form of electronic signature gathering. The real issue here, Your Honor, is with receiving the data that appears as if it's been affixed to a nomination paper, but instead of submitting that nomination paper back to the campaign, it's simply sending the raw data divorced from the nomination paper to the private company, later to be mail merged onto a new document.
Okay, so let's just explore that. By saying the PDF would be sufficient, I think you are conceding, I think appropriately so, that the location of the signature is not enough to defeat Ms. Brady's nomination.
No, I don't think, well, it might come down to an analysis of the actual individual signatures that were submitted in that case, because the local election officials have to be able to look at the form and determine who it is that is signing this nomination paper and whether, in fact, they are registered at the address that's shown there. So it may be that in some circumstances, those original PDFs, the signature was not legible enough in order to know which voter this was. So it's possible that not all of these, that if the campaign had simply sent in what was originally issued to the voter as a receipt, that not all 1,066 signatures would have been certified. And if that's a bit confusing, I direct Your Honor to the example in Commission Exhibit 5, which is at Volume 13, page 10 of the administrative record. So there you can see this is actually a receipt for a nomination submitted to Rayla Campbell, not to Helen Brady, but the system works the same way. You can see that the signature in that particular example is not really legible. You can't tell the name of the voter that's signing here. And in those original receipts, the voter's name was not printed next to the signature. So it's possible that this particular signature would not have been certified. However, in terms of the principle of the thing, I'm not sure that the commission would have had a problem with the process if the receipts themselves had been returned to the campaign instead of the new nomination papers that were generated after the mail merge.
But substantively, you have much more information about the voter who signed it than if you had gone to town center and had the person sign his or her signature. All you'd have would be a signature. You wouldn't even have the name. You wouldn't have all the other information which was on that PDF, which could allow you to verify the identity of the voter.
There's no additional information on this PDF except there's a small stamp that says signed at, and there's a date and time that this was signed. But otherwise, this is essentially the same information that you would have if you went to Town Center and asked voters to sign a nomination paper. You would have the signature of this individual. Hopefully you can read it, or you would have a printed name next to it, and then you have the address at which they are registered. I don't think that this program provides any additional assurances that this is necessarily the person who signed than in the ordinary context.
All right. So you've identified some other cases, but are there any cases, I mean, here, there's no dispute that more than 1,000 people signed nomination papers for Helen Brady, correct?
Yes, that's correct.
And that they knew that she was a Republican.
Yes.
And they knew that she was running for the particular district against Representative Keating, although his name probably was not on it, but they knew the district.
Yes.
So is there any case we have, you mentioned a case where they may not be sure of the party, but that's not a problem here. And is there any case in which we can say, yes, we know?
Now exiting.
Jim Roosevelt.
Is there any case in which we know that more than 1,000 people signed, and yet we say, because of a matter of form, essentially because the person here did not send in the PDFs, but instead did their mail merge, that we're going to say you can't do it?
Well, by definition, we don't have any other examples involving electronic signatures because this is new. However, I could just have a moment.
We've been having nomination papers with real wet signatures for quite a long time. But I don't know of any case in which we say, yeah, you got the necessary amount of signatures, but there is something about it. And we know that the person sought to nominate you for this particular position from this particular political party, but we're still going to say no.
Well, in the Garrison case that I mentioned, as I said, there's no evidence that the voters did not know that they were nominating that particular candidate for the nomination for Democrat. But rather, it was the absence of information available to them, or was the absence of information required under the statute that made these nomination papers insufficient. And I think this is a similar context in which the voter could have been misled, was not in fact misled, but could have been misled by virtue of the use of a process where what was ultimately submitted was not the same as the document that she affixed her signature to.
Where in Goldstein, I know Goldstein says that the Secretary shall accept electronic signatures as described in the opinion, and I know that the opinion authorizes this, but you argue that it's more than a safe harbor. You argue that it is an absolute defining element in that if somebody were to say we have another way to do it, that we would say, no, you can't. We will not consider another way to do it because Goldstein defines the only way to do it. What is the language you're focusing on to interpret Goldstein as saying it's this way or no way?
Goldstein specifically discussed that ordinarily this court would defer to the legislature in terms of making what is essentially a new determination of policy like this, that electronic signatures are going to be allowed at all. And the language that I would point the court to is our remedy must be no more intrusive than it ought reasonably to be to ensure the accomplishment of the legally justified result. Here, what was legally justified was a relatively narrow alteration to the usual process by which signatures are gathered, that essentially allowed candidates to reach voters in their homes rather than having to approach them on the street.
Okay, I have no further questions. Are there any further questions of Ms. Kaplan from any of the justices? And hearing none, we thank you and we'll turn to you, Mr. McDonough. You have 5 minutes.
Thank you and good afternoon, Your Honor. I'm Gerald McDonough. May it please the Court. I'm counsel for the interveners, appellees, Massachusetts Democratic Party, and Leon Arthur Brathwaite II, the objector in the underlying proceeding in front of the State Ballot Law Commission. I'm not going to go into great detail here. I think what I'd like to do is to try to respond to some of the questions that have been asked, and I might have a different wrinkle in the way that I respond to them. Regarding, for example, the speeding argument, I think it's more appropriate to say that Helen Brady was the only person who was pulled over by the state police. And then the state ballot, when the objection was filed, and then the State Ballot Law Commission gave her the ticket. I don't think it's appropriate to say that that this is similar to other people being pulled over. Regarding the difference in the nomination papers between the PDF, if there is one that was the original one that was signed by the voter, and the one that was submitted to the local registrars, a critical, important difference in there is that the name of the voter on the final PDF that was not shown to the voter initially has a typewritten version of the person's name on the signature line. Now that is incredibly important because there is no way local registrars in the normal course of events would have approved as many of these nomination papers as they did but for that name appearing on that signature line. For example, there are at least 15 nomination papers we have where the signature line is blank except for that typed name of the voter that was put in by the vendor. There are other signatures which are just initials which are not permissible, and then there are illegible signatures that no single registrar would be able to ascertain who the signer was. And I can just suggest you look at the exhibits that we filed. When this case was initially filed, we had two grounds for it. One was for the electronic signatures, and we didn't have much information on that. Most of the information that we have, and is before you, comes from Mr. Fitzgibbon's testimony before the commission. And the other ground was that we thought that there were hundreds of nomination papers that were illegible. There was no name there. There were initials that were put in there. The commission, though, put that question aside and dealt with the electronic signatures. But if you took the PDFs originally and sent those back to the registrars without the printed name of the voter, there was no way that the registrars would have been able to ascertain hundreds of those signatures. They're just illegible. Now, regarding the question about fraud, nobody is alleging fraud in this case. But I know that the Secretary has the authority, and I can't find the statute at this point in time, to investigate issues of fraud in different election procedures. And I myself have filed a request to the Elections Division at one time to investigate allegations of fraud. And I think that the issue about other vendors who use this, I would suggest that you look at my brief and look at the long, on page 20, you look at the long recitation of information by Mr. Fitzgibbon, where he precisely testifies that other vendors were following the instructions in the Goldstein case. The problem they had was they didn't get as many positive results as Mr. Fitzgibbons was getting with his. Mr. Gibbons didn't get 100% return on the signatures either. There were about 1,400 signatures, electronic signatures that Ms. Brady had, and she ended up with over just slightly, 1,066. So many of his didn't work as well. But he testified that other vendors were using DocuSign and other kinds of technology that complied completely with the Goldstein provisions. So with that, Your Honor, the only other thing I would like to say is to the extent that the appellant here is seeking the court to exercise its equitable jurisdiction because of the COVID-19 pandemic, it's important to understand that the appellant herself has some degree of burden to share here with the pandemic. The nomination papers were released to candidates on February 11th. 41 days later, the governor issued his emergency order. During that entire period of 41 days, the appellant didn't obtain one single signature. Then over the next however many days it was, 14 days or whatever, until we got to the Goldstein decision. In that period, lots of candidates were sending out nomination papers by mail, getting them signed and getting them returned. The appellant did nothing during that period. And for 11 days after the Goldstein decision issued on April 16, again, the appellant did absolutely nothing. It was not until April 27th that the appellant got her first signature, and that electronic signature, and that signature was obtained 8 days before the deadline. So in a nomination signature gathering time frame of 84 days, the appellant waited until the 76th day to start collecting signatures. So part of this is her own problem, Your Honors, in terms of her procrastination in this, and I think that weighs against providing any equitable relief to her.
Okay.
So with that, I'll take any questions you have.
Justice Lang, any questions?
I'm all set, thanks.
Justice Gaziano?
No questions, please.
Justice Lilly?
No, thank you.
And Justice Safer?
No, I'm fine. Thank you.
Justice Caffrey?
All set.
And I've got no questions either, so thank you, Mr. McDonough. Before we close, Ms. Kaplan, I know we have a deadline to decide. Is it close of business on the 13th, or is it close of business on the 14th that we need to have a decision?
I know that the ballots need to be finalized by the 14th. I think close the business on the 13th would be safer because I would be concerned that the end of the day on the 14th would be too late.
All right, so we basically have until Monday close of business.
Yes.
Okay, we will get it done somehow. All right, thank you all.
Bye-bye.
Thank you, everyone.
Hearing, before we leave, our ensemble will be at 3:15.
Okay, good. Thanks.
Okay, thank you.